23 CR 99. And it's called the State of Texas versus Michael McCrae Duncan. You are Mr. Duncan.
Yes, sir.
Present with your attorney, Mr. Galmore, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in start?
He does.
In summary, this indictment alleges that on or about September 30th, 2022 in Jefferson County, Texas, you operated a motor vehicle on a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more DWI convictions. Paragraphs 1 and 2 constitute a third-degree felony if found guilty. Do you understand?
Yes, sir.
A third-degree felony carries with it, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between the parties. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on probation for 10 years. And there will be, and also as a condition of probation, you must spend 10 days, right?
We made an agreement for 15.
Hold on. Under the law,
That's correct, Your Honor.
you must spend at least 10 days
Yes, Your Honor.
in the county jail as a condition of,
Yes,
it could be up to 180 days, but the law says at least 10 days in the county jail. And there's a non-binding recommendation that you would be ordered to perform 15 days in the county jail on weekends, which would, you only get 2 days credit. So that would be 7.5 weeks. 8 weeks. You would have to serve that last week, only 1 day. If my math serves me.
That's correct.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to paragraphs 1 and 2 in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
And paragraph 2 of the indictment, which alleges these prior convictions of on February 8th, 2013 in County Court of Chambers County, Texas, you were convicted of a DWI. And also on November 20th, 2013 in County Court of Law 2 of Jefferson County, you were convicted of another DWI. Are those allegations in paragraph 2 in this indictment true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily? And because it is, those allegations are true.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, it states, so help you God. Is that so?
Yes, sir.
And Your Honor, just with regard to restitution, there's potentially a small amount that's still owed. I know there was a settlement between the individuals who they were the back of their vehicles ran into that they I know they settled most of, if not all, of the claims, but there could be still a small amount out there. So potentially, once I speak with the party to determine if there's any, I'll let probation know the amount.
So restitution is ordered in some amount that the parties agree will be determined by the post-sentence report in the probation office. Is that right?
Yes, Your Honor.
Okay, that's correct.
Yes, sir.
All right. Because by law, restitution has to be ordered at the time of sentencing. That was a very important issue in a very important case that was taken up on the Court of Appeals out of this court, which we had followed. But it was one of those which had to be determined. And they said that was, as long as restitution is ordered in an amount to be determined, then there's a period of time, a reasonable period of time where it can be determined, and then that order of restitution would be carried out as part of the judgment. If nothing further, I'm going to find you are pleading guilty and true to paragraphs 1 and 2 respectively of this indictment voluntarily, knowingly, intelligently. There's sufficient evidence supporting your plea of true and guilty from State's Exhibit 1 admitted here to support all of your pleas to find you guilty beyond a reasonable doubt, as I find that you are pleading guilty voluntarily, knowingly, intelligently, and because that is what you wish to do. I accept your plea, find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle in a public place while intoxicated, according to paragraphs 1 and 2 of this indictment. I am following this agreement. You were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years. That term of 10 years confinement shall be suspended. You were placed on regular probation for 10 years. There is no fine. However, restitution shall be ordered in an amount that is what is agreed upon by the parties, that is not covered and already fulfilled by insurance reimbursement. Do we know about what it is?
I know last time when I spoke with,
What was the
there,
total
I
amount?
think it was around $1,300, but
What was the total amount that the insurance was?
I'm
That was
not sure. I know there was an indemnity agreement. They settled out all the claims of it. I know that's what the victim in this case told me, that I believe there's roughly $1,300, but that was still waiting to be settled out.
Roughly $1,300 what?
In restitution, it was medical bills, I believe.
That's still unreimbursed?
That's correct, but again, I need to update that and see if that was settled or not, because they were settling with his insurance
But
company.
there was an amount that
A small amount, yes, you're
That
right.
was- that is reimbursable somehow in one way or the other to the victim in this case, or the complainant,
Yes,
correct?
yes.
Everybody agrees. Right, then, you're nodding your head, Dustin. Well, this court is ordering restitution in an amount to be determined by the post-sentence reports. If there's an issue on that, let me know. We'll deal with it. There will be other terms and conditions of probation, such as a DWI repeat offender program. You okay? All right.
Alex.
366 in Honolulu. I used to jog there when I was a little kid. I lived right off of Honolulu. And 366 was a major intersection. There was a chemical company that was right there at that corner, right across from, it's Huntsman now. That was Jefferson Chemical, but across the street from there, would have been the south side of 366 was a small company that was boarded up and fenced off and had all kinds of security around it that the United States government had. They made Agent Orange.
Interesting. You didn't know that.
Yep.
Yeah. Smart to plus.
Anyway, that's what I know about that intersection, but it's a major intersection. What was the alcohol content on this event? Y'all know?
0.316.
Good Lord. You need, hello, unless you've gotten a grip on it, you need some help. 0.30,
316.
316. Well, that's 4 times the legal limit. Do you see anything wrong with that? What are you doing about it? Because operating a motor vehicle while intoxicated is a very selfish thing, you know, because everybody is at risk. I'm gonna roll everybody's eyes, but this is a 4,000-pound missile you're operating, and you're high as a kite. Too often, people come in here who have been seriously injured or killed, and there's nothing more sad than those people wondering how that happened to them or their child or their relative when they were following the rules and someone was operating a 4,000-pound missile recklessly and out of their mind. It's a very selfish thing to do. We have to share the road with everybody. But you have to appreciate the next person's life, that you care. If you don't care about yours, which would be foolish, you need to care about all the people who are trusting other drivers to be responsible. But we see it over and over again, and it's catastrophic. I mean, it's gruesome. And that's the case where we have more people weeping in this room, wondering how that could happen. I mean, you got to get a grip on this. This is your 3rd time, but when you were in an accident here, a collision here, well, you're lucky. You know, people go to prison if someone is injured or killed generally in a DWI. And if you're killed, we've tried in my 17 years here, we've tried 5 or 6 jury trials. Every one of them received 20 years max. Every one of them, the jury did that. So I have a sense of what the people in the community think of this. We know people drink. We know they drive. But if you kill somebody or seriously injure, the 12 jurors who sit over there have no sympathy except for the victim. 20 years maxed every time. We haven't had a jury verdict less than the maximum. That's how serious it's thought of universally. Scam. Well, you got 250,000 people who are frowning on your behavior. So you got to fix it, or you'll be held accountable. Now, here. This one's like, doesn't say anything about what happened to the other driver. What do we know? What do we know?
As far as the driver of the vehicle we
Were
rented.
they injured?
Yes, Your Honor, and they settled out. I know she had
couldn't care less.
I believe she had
about that. That's
pre-existing back injuries, and it exacerbated that when they were ran into the back of the vehicle.
what ran into the back of the vehicle.
Yes, Your Honor.
All right. As a condition of probation, you must serve 15 days in the county jail, and those will be on successive weekends. You go into the jail on or before 6:00 p.m. They release you at 6:00 p.m. on Sunday, and you get 2 days credit. And when are you able to begin that?
January 26th. It's Friday next week.
Friday week. You must report on or before 6:00 PM in the Jefferson County Jail Friday, January 26th, and each Friday thereafter at that time until you have been credited with 15 days service in the county jail. Do you understand, sir?
Yes, sir.
Okay. Also, we must include the restitution. Okay, why am I getting this judicial clemency? He's not eligible for judicial clemency for a DWI, is he?
No.
No.
It's always attached on the adjudicated forfeiters.
I know we normally do, but when you're not eligible for it, there's no reason to waste everybody's, I'm not going to sign it because he's not eligible for it. He doesn't get it. Then I don't have any kind of option under law. That's only for people who are eligible for judicial clemency, but you're not for a 49, a section 49 offense at DWI. I don't want the paperwork to get in there and then we inadvertently grant it because it would be a contrary to the law. Okay. Anything else?
No.
That is all. Thank you. Please see the probation officer.
Don't need to, we don't need,